Wah, lori na do.
Yo kisum kose fi.
Ada tu.
Sawa.
Yo TV pong.
TV pong aneni kawuono yuan.
Pesa Inona. Where's your glass, Mr. Where's your glass? Victor Uma Kota Govings. You wait. I know, Stephen, you are waiting. You stop interrupting. Your mother will be called. You wait.
Yes. You know the application before you is dated today. Was discovered.
Was present.
At a scene of crime where the deceased was abducted. Money from various M-Pesa agents. Instead, the respondent escaped to Nairobi. Image resembling the respondent was captured by CCTV cameras, making this procedure will take it is also organized up investigations. Yes. Your Honor, I wish also to die, and in view of the Your Honor, it is also good for this court to note that the accused, the response mobile phone that is Redmi as per paragraph 13 carry out forensic analysis. That's all, Your Honor, and I wish to rely on the order does it what paragraph.
Will be held at Railways Police Station, Kisumu, or any other police station within the Republic of Kenya for a period of 30 days. 2. That the Honorable Court makes other orders that it deems fit. During their submission, Learned Counsel for the State, Mr. Soita, asked this court to give an order that the cell phone read me, IME number that, and further that the service provider to provide the subscriber details of the ITEL SIM card, ICCD number that. I have considered the application and the affidavit in support thereof. I have further considered the submissions by both the Learned Counsel and the IO. The rights of an accused person are anchored under Article 49 of the Constitution of Kenya. Article 49(1)(h) of the Constitution provides that an arrested person has a right to be released on bond or bail on reasonable conditions pending charge or trial unless there are compelling reasons not to be released. From the reading of that sub-article, it is clear that the right to bail and bond is not absolute, but rather is subject to some limitations and conditions. It can be denied where there exist compelling reasons to do so. In the case of Republic vs. Sifuna, criminal case number E014 of 2023, it states, and I quote, Section 123A of the CPC sets out exceptions to the right to bail and bond. The provisions was brought on board with a view to align the CPC with the Constitution. The circumstances, end of quote, the circumstances under which bond or bail can be denied is as follows: that the nature of and seriousness of the offense, the character, antecedent, association, and community ties of the accused person. 3. The defendant's record in respect of the fulfillment of obligations under previous grants of bail and bond. And 4. The strength of the evidence of his having committed the offense. The question is therefore, has the prosecution presented compelling reasons to permit the defendant the detention into police custody of the respondent and denial of bail or bond? The state submits that they are investigating the offense of murder contrary to Section 203 as read with Section 204 of the Penal Code. Further, that upon commission of the offense, the respondent ran away and hid in Dandora. Furthermore, due to the nature of the offense and how it was committed, the deceased family, friends, and community are angry, and they may harm the respondent if he is released. It is for this, and therefore it is for his own safety that the respondent is held in custody. The state is asking for 30 days to detain the respondent pending investigation. The reasons being that they would want to trace witnesses, record statements, and conduct ID parades. That the investigation involves multi-agency, therefore it requires time to do the same. I take judicial notice that the offense alleged to have been committed is a serious one, and if the state proves at the trial, it has a potential of committing the respondent to life imprisonment in accordance to the case of Muruatetu. If the respondent is released pending investigation, he has the potential of running away outside the jurisdiction of the courts in this Republic of Kenya. Further, due to how the offense was committed, this court does not live in utopia. It is acutely aware of the temperatures generated by this case and the offense. It will only be prudent and in the best interest of the respondent to allow the application by the prosecution. Based on the foregoing, this court orders the following: that the respondent shall be held at Railways Police Station, Kisumu, for a period of 21 days from the date hereof for the police to conduct and conclude their investigation. B. That an order be and is hereby issued that the cell phone number make Redmi Note Pro IME number that be subjected to forensic examination. C. That an order be and is hereby issued to the service provider Airtel Kenya Limited to provide to the investigating officer, herein Inspector Oliver Nabonwa, with the subscriber information in respect to Airtel SIM card number that. D. that the respondent shall be subjected to mental assessment. E, that this matter shall be mentioned on the 21st day of November 2024. It is so ordered.